Thank you so much for joining us for this webinar.
Thank you.
So guys, welcome to this session on LawSikho. My name is Shweta Rath. I'm operating out of Komal's account. And today, as known to all of you, our discussion would be pertaining to competition law. Now, why this session is also very interesting for people from all realms of law, because we'll be discussing a very hotly debated and like a favorite subject in the competition area, the conflict that this particular act faces with other areas of law, and the conflict that it has with other regulatory bodies especially. So that will be mostly the topic of our discussion. And I would like to introduce the expert for our session today, Mr. Avinash Amarnath, once again. Thank you so much, sir, for coming in.
Thank you.
Thank you, sir. If you could actually give a brief background about yourself before we start with the webinar, so everyone over here is aware.
Okay, sure. Not too much, but yeah, I started off as a competition lawyer. I did right after law school, I did an LLM with a specialization in competition law, and then worked in the competition law teams of Shardul, Amarchand, Mangalgas, and Talwar, Thakore and Associates. After that, I was Mr. Amit Sibal's junior for around a year and a half, where apart from competition, I did other types of litigation as well, including regulatory litigation before the TDSAT, APTEL, etc. And now I'm an independent lawyer practicing in the Supreme Court, CCI, NCLAT, and other forums.
Perfect. Thank you so much, sir. So just to give like an introduction, brief introduction about this particular area of law to people who are not very well versed with competition, if you could just say what briefly attracted you about this area of law, and more importantly, what are the differences you find right now in terms of scope between when you started practicing competition and in today's times?
Yeah. So I think to put it very, very briefly, so what attracted me to competition law was that the competition law is all about economics. I've always had a keen interest in economics, and competition law is essentially an economic law. So it was a natural kind of attraction. I think the other byproduct of competition law being a economic law is that you get a wide area of play with the law, because the law is very broadly worded, so you really have a lot of interpretation to do. You can think creatively. So I think that was the other thing. And so essentially, I mean, for people who are not aware about competition law, it is a law that regulates the process of competition in the market. It works on the assumption that competition and free market is good for the economy, and it has to be protected and preserved. So therefore, to protect that fair process of competition, we have competition law. It primarily regulates three areas: anti-competitive agreements, abuse of dominance, and any kind of mergers and acquisitions which may result in a adverse effect on competition. So, and in terms of what has changed between when I started and now, I think we've progressed a lot, because when I started off, competition law was very, very new. Although the law was enacted in 2002, the major provisions came into force only in 2009. So when I started off practicing in 2012, it was very early days. We've come a long way since then. So I think just in terms of the number of cases, the areas that the CCI covers nowadays, the staff, the expertise that they've developed, it's very different. And generally, I think we are moving in the right direction. So I think it's a good time to be a competition lawyer, and even for anybody else who's interested in competition law, there's still a lot of work out there. So it's still a growing area of law, I would say.
Absolutely, absolutely. And as you rightly mentioned, that it is a growing area of law, and what has actually grown even more is its interface with other areas of law, which is the topic of our discussion today. So, if we come to the topic of today, what do you think, if you were to say from an experience as a competition lawyer and your experience of having dealt with people who have not dealt with competition law, what do you think are the informational gaps that are prevalent, or the things that they should be knowing about while dealing with regulatory areas where there can be a competition interface.
Yeah.
So what has been your experience there before we actually get into the substantive part of our topic?
Absolutely. So, at the top of my mind, I think and two things which I notice very often, which perhaps somebody who has not done competition law before, two very common, I wouldn't say mistakes, it's because it's just a matter of, experience and knowing what to do, but two traps they fall under is one is to read the law literally, because as I said, competition law is an economic law. So you have to understand the terms that are used in the law in an economic sense. So, to read the law literally sometimes gives you very absurd results, and you have to have
Give
that
an example
background.
to that in your experience when you've seen lawyers have read the law literally and what was the actual interpretation of that particular term?
Well, for example, I think the most confusing term that's often used is relevant market.
Yes.
And what is a relevant market? When you just read it, when you read the definition under the Act, although the definition is economic, if you just apply it literally, you could just, differentiate between, for example, a matchstick and a lighter and say that, look, they're different in characteristics, they're different in price, therefore, how are they in the same market?
Absolutely.
Without understanding that actually what you're looking at really when you look at relevant market in economic terms is whether two products are substitutable from a consumer's perspective. So you have to look at the end use of the product. And there are, several other factors that go into it. So very often you see that people try to, of course, we all do it, but sometimes people try to define markets according to their own convenience without understanding the whole gamut of factors that go in.
Absolutely.
And sometimes even what is dominance or what is monopoly, there's a very big confusion. So, for example, people often get confused between what I would call contractual dominance and market dominance. So, for example, I've had a lot of clients, even when I'm discussing with people, they come to me, they say, look, there's this insurance contract that I signed. And when I signed, I didn't know that there were so many one-sided terms, but, now I'm trapped. Can I do something? Isn't this dominance? So, I have to explain to them that, look, when we say dominance in competition law, you have to look at the whole market. Absolutely. Not just your contract. Your contract may have one-sided terms, but you signed it with open eyes, and you had other choices. That's the competition law concept of dominance, not what we look at dominance in the other
part of it.
Yeah, from a layman perspective. The other, I think, often the trap that people fall into is to think of competition law as another forum for agitating their inter-party disputes. So what I mean is competition law is an in rem proceeding. So when you approach the Competition Commission as an informant, you are literally that. You're not a complainant, you're an informant. You're just giving information, and then the CCI will look at the entire market and study the practices of the enterprise. So it's not a civil suit. It's not a forum where you would get damages immediately. Absolutely. So I think that's another area where people often get confused, that competition law is just another forum to vent your personal disputes with a party. That's not. It could be that those personal disputes also have a wider competition angle. Yes. But you have to make out that wider competition angle in competition law.
Yeah, I think one of the biggest confusions they have is they sometimes confuse it with the Consumer Protection Act, where they come from a very consumer perspective. Absolutely. But they don't realize that competition, the CCI will first look at the needs of the market, and then obviously which percolates eventually to the needs of the consumer.
Absolutely.
It's not the other way around.
Correct. Absolutely.
Great. Thank you so much, sir, for this brief introduction for at least people who do not practice the law, because quite often these areas are not very clarified to them, that what are these informational gaps that they usually have. So now if let's say we're getting into the topic of our hand, that what are the conflicts that CCI faces with other regulatory bodies? When I say regulatory bodies, I think I've identified 5 or 6 very prime areas that we will eventually deal with in our conversation. That when we are discussing with areas with respect to the telecom sector or the IP sector, specifically in the patents and copyrights area, then the oil and gas sector, electricity and SEBI. Like these are the ones that at least I have identified from my end. Please feel free to add even more as per your experience. So would you want to give like a brief introduction to all these things, or do you want to start taking up every area one by one?
No, I think let's start with a brief introduction because I
Yeah.
think it's important to understand the perspective.
Yes.
So, I think this firstly, this problem is not. Firstly, it's not new. It's an
Yes.
age-old problem. Second, it's not specific to India. Every country in the world has it. And I think the reason why we face this problem is that we are all, all nations are moving towards what I would call is a regulatory economy.
Yes.
So, traditionally we had two different, we had the laissez-faire or the free market system where it was completely driven by the market, or you would have, the USSR kind of, where state-controlled economy. Slowly, I think people and, the economic thinking, it has realized that neither of these two extremes are actually desirable, but both have certain positives. So the
Absolutely.
regulatory economy, in a sense, is a midway. So where you recognize that generally free market is good and free market improves efficiency, but the free market may at times lead to certain anti-consumer, anti-competitive outcomes, and therefore you need regulators and you need specific regulators for each sector.
Absolutely.
So almost all countries are going towards that. So you would see that any big sectors of the economy will usually have their own sector specific regulators. So obviously when you have so many regulators, it's but obvious that a regulatory conflict arises because sometimes there's
Yes.
an overlap and conduct comes into overlap. And that's where, we have this problem.
Absolutely.
Now, in terms of how different countries have dealt with it, I would broadly say that there are, three systems.
Hmm.
One is the US system. So what the US does, and all of this is specifically in relation to competition law. I'm sure if there are other regulatory conflicts, there might be different ways of dealing with it. But as far as I'm aware, at least as far, in relation to competition law, what the US does is the US has a very clear exclusion system. So what they do is they'll look at the courts will look at a particular sector and look at the laws laid down. And if they come to the conclusion that those laws are a complete code and they are enough to deal with competition problems in that sector, they completely exclude the application of antitrust or competition law.
Absolutely. Yes.
So this has happened, for example, in the telecom sector for them. There is a clear US judgment. It has happened in the securities market. There's a judgment called Credit Suisse, where the US Supreme Court came up with the concept of an implied exclusion, which is
Hmm.
that, when the regulations are so exhaustive and the regulator has such wide powers that it impliedly excludes antitrust law. So this is
Absolutely.
one method of doing it, that you say that, okay, anything that the sector regulator has, let him deal with it if he has the powers. Don't mix it up. The second system is the UK system. In the United Kingdom, what happens is there every sector regulator has the power to enforce competition law in their specific sectors.
Yes.
So, for example, just to give you an example, so the in the UK, the OFT or sorry, not the OFT, the Ofcom or the Office of Communications is the TRAI for them. They deal with all the telecommunications and broadcasting space. That they are the sector regulator.
Yes.
So they have the power to enforce competition law as far as telecom sector is concerned. So what the UK has done is they've said, look, we have a competition authority, but that competition authority will look at competition issues for all those sectors where there's no specific regulator. Where there is a regulator, we'll let the regulator themselves enforce the competition law. That's another system. The third system, which recent, and we'll come to this in more detail, but this is the Indian system, which is what I would call a sequencing system, where the Supreme Court in the Bharti Airtel judgment has, and this is of course, this judgment, there's several rounds of interpretation happening of what this judgment means and all of that. We'll come to that. But broadly, I think the ratio that Bharti Airtel lays down is that if a sector regulator is seized of certain jurisdictional facts, then you first let the sector regulator decide and then the CCI can come in. So
Right.
it's kind of like a sequencing. You wait first the sector regulator, then the CCI. Of course, there are problems with it, which will come, when we discuss the sector-wise issues. So, these are the three broad systems, I would say. And, and how do you want me to, should we discuss the judgments now or should we discuss it sector-wise?
Actually, let's do it sector wise. I think that will be easier for people to relate to it. So, so let us start with the most debated sector I think there is, that is the telecom sector, where the maximum amount of scrutiny and probably the judgments have come in. So how do you think the telecom sector has had like a spillover effect, or the CCI is having a spillover effect in the telecom sector in the realm of competition law? What have been these areas of dispute that have come across
Yeah.
in various cases?
So I think, and this is again, these are my personal views, and I'm sure people on the webinar would have their own views, so which they are free to. But from my experience, what I've seen is that I think the reason why telecom is such a hotly debated topic and why there's so much overlap is because the TRAI has also been very, very proactive on competition issues in their sector.
Yes.
So they have a lot of regulations, right from controlling the price of products, looking at whether parties hold dominance. They have market share thresholds for deciding who's dominant.
Yes.
And very, very extensive regulations. Even recently, I think they were considering issuing regulations on predatory pricing as well.
Yes, they were.
So yeah, so there's a huge overlap because TRAI has a lot of detailed regulations on core competition issues. So it was but obvious that disputes had to arise. And of course, the two famous judgments in the telecom sector, and actually this is where the telecom sector thankfully has given us some law which we would apply to other sectors as well in the future, because that the Supreme Court has had a chance to look at. And so the first judgment is, of course, the Bharti Airtel judgment.
Yes.
So in Bharti Airtel, I think everybody would know this was that famous telecom war when Jio entered the market. Yes. And it accused the other three, that's Idea, Vodafone and Airtel, of denying it market access by collectively denying points of interconnection. So points of interconnection are basically they are basically points where a call starts on one network and ends on the other network. So these points of interconnection are the reason why if I have an Airtel number and you have a Vodafone number, we are able to call each other. So Absolutely. It's critical to be operational in the telecom sector to have these POIs. Now, what Jio had done was they had approached the TRAI separately and saying that that these three telcos had violated the TRAI norms. They had not given the POIs on time. They had not adhered to the agreement, what we call the interconnection agreement that these parties had, etc. Separately, they also came to the CCI and alleged that there was a cartel between the three telcos to deny access to Jio.
Yeah.
And again, okay, before I proceed further, I have represented Jio. So, if these are again my views on this matter, people are free to have their own views. So what happened was, the CCI found a prima facie case. They directed investigation. The telcos took that order and challenged it in the Bombay High Court. And the Bombay High Court essentially came up with this reasoning that no, the sector regulator is it's the expert body. So when it is seized of a matter, the CCI ought to have waited. And the Supreme Court upholds that reasoning. And while doing so, lays down this principle, this Indian system, as I call it, of sequencing. Because what it says, two things are very important here. What it says is, one, there must be jurisdictional facts pending before the sector regulator. Yeah. Now, and I'll tell you why that's important. Why it's important is because what is a jurisdictional fact is not very clear from the judgment. And and because that's not clear, unfortunately, we are seeing a situation where the CCI's jurisdiction could get stalled unnecessarily. So number one, it says yes, there has to be a jurisdictional fact pending, and if there is a jurisdictional fact pending, then the CCI ought to await till that body decides.
Absolutely.
Right. Now, according to me, there are two problems with this. So number one, as I said, what is a jurisdictional fact becomes very important, because at least in my view, on the facts of this case, the jurisdictional facts pending before TRAI were very different from the jurisdictional fact pending before CCI. Because what the TRAI was looking at was whether its norms were not adhered to, which means that was the POI not given within 90 days? Was it not in accordance with that interconnection agreement? Was it not in accordance with that regulations? The TRAI was...
Yeah.
Sorry?
Like, are you saying there were procedural issues that the TRAI was looking
Yeah, so they were looking at, essentially they were looking at whether there was a violation of their regulations.
Absolutely, yeah.
Right, but they were not looking at whether the three companies had collectively colluded to deny POIs. Now that is, according to me, was the jurisdictional fact before the CCI. and the two were independent. See, because otherwise I do see the reasoning of the Supreme Court, because if it's the very same jurisdictional fact that's pending before two regulators, then yes, there is a problem of judicial conflict.
Yes.
Because if it's the same fact, whether I committed an act X, and if one authority says yes and the other authority says no, then clearly there's a judicial conflict there.
Yes.
But on the facts of this case, at least in my view, it was not the same jurisdictional fact pending before the two authorities. So, in future cases, it becomes very important to delineate what exactly is a jurisdictional fact, because otherwise what will end up happening is that just because a dispute may be pending between the same parties in some other forum, which may be completely unconnected to the controversy here,
Absolutely.
parties can easily stall the CCI proceedings. And, that is an unintended, I think, and an unfortunate consequence if that is what ends up happening. The second problem with this, sequencing point is the Supreme Court says you have to wait till the sector regulator decides. Yeah. Now, then there will be an appeal from the sector regulator's decision. There's a sequence of appeal. It will go all the way to the Supreme Court. This could take 7 to 8 years. So, does the CCI then have to wait till the entire litigation before the sector regulator reaches its finality? In that case, it may become futile, because it may be 8 years and 10 years down the line. But, anyway, I mean, these are my thoughts on this judgment. But this, for good or bad, the law in the telecom sector, at least now, is Bharti Airtel, which means that, the sector regulator, if it is seized of jurisdictional facts, it gets the first jurisdiction. There is an added dimension to this. Now, there's another Bombay High Court judgment in Star versus CCI, where Bharti Airtel was then applied to a slightly different context, but again, relating to telecom. This was in the broadcasting space. So here the issue was, does this dispute that's pending before the sector regulator have to be an in personam dispute or in rem?
Absolutely, yes.
Because the CCI's argument there was that there was already one order of the TDSAT, which had, on the broad general industry-wide issues, it had given a finding. But the specific issues in relation to this informant was still pending. So the CCI and the informant tried to argue that, look, the in rem proceeding is done in the TDSAT. So therefore, there's no pending dispute as of now, and we can proceed. So again, the High Court here says, and I think rightly so, they say that no, it's not just about in rem. You also, even if an in personam dispute is pending before the sector regulator, you have to wait. So again, the CCI's order was quashed in that matter as well. So yeah, so I mean, in the telecom sector, I think we are seeing quite a lot of movement, and there is at least some clear precedent. Of course, it's not without its problems, but
also,
yeah.
My personal query on this issue is that in case a party does pursue the telecom authority, the telecom sector authority, maybe the case must have started. Now, what is the kind of order that will come out? Because when we approach the CCI, the order kind of comes out in the nature of that, okay, these parties have colluded with each other and hence the penalty is being given out because of the collusion. But I'm sure that kind of an order will not come out from the TDSAT. It would more be like an individual penalty or something. They won't actually address the main issue that is happening.
So as far as collusion is concerned, you're right, because that is something that the TDSAT will definitely not look into, because collusion is something that's only in relation to competition law. But when you come to abuse, the line becomes a little murkier, because TDSAT and TRAI have their own regulations in relation to when a company can be said to be dominant. Is it indulging in discrimination, etc. So in fact, like for example, in this Star matter, the fact was whether Star and Sony were discriminating between the informant, who was one type of a distributor, you would say. So there are different types, as you know, there's DTH operators, there are MSOs, etc. So he was something called a HITS, or a head in the sky operator. Yeah. So the issue was whether Star was discriminating between him and other types of DTH or MSO operators. Now, the question here, the fact was, were they similarly placed or not? Now, that would entirely depend on the technology that they use and on the TRAI regulations, etc. So, in this case, I would say that those facts are quite similar to, so for example, if the TDSAT had concluded that they are not similarly placed, then the CCI, because the CCI can only proceed on discrimination and abuse of dominance if there's a finding that they are similarly placed. But if the TDSAT has concluded that they are not similarly placed, then you have a judicial conflict. So there are situations, I would say, where the finding of fact of a sector regulator would have a bearing on the competition proceedings. So it's not that,
scenario in this another case of Fastway also, where
yes,
it was again adjudicated by the Supreme Court that this was a agreement issue, like there was an agreement, there was a disagreement between two parties, which had led to a termination. And the TDSAT was viewing it from a very procedural perspective that, okay, these criteria were not met, hence terminated, and which is correct. But the CCI was looking at from an abuse perspective that, okay, the termination was kind of a bully tactic that was used by the parties.
Exactly.
Things are not something that the TDSAT will actually look into or will have the bandwidth to look into.
Absolutely. Absolutely.
Absolutely. So, so these were the issues. These are the prime issues that come out in the telecom sector. Now, moving on to the next sector, that is with respect to IP and specifically patents, which has again been another hotly debated sector. What has been the CCI's experience in terms of overlap in this particular market?
Yeah. So in IP, of course, you have the one really famous judgment of Ericsson. Intex and Micromax, who are your phone manufacturers, they've had long-standing intellectual property disputes with Ericsson. So Ericsson owns almost a lot of the patents in relation to 2G, 3G, 4G technology, and they make. I mean, that's pretty much their modus operandi. They make their money through licensing those SEPs. So there's a long-standing IP dispute that's happening with a lot of manufacturers about royalties, etc. I would say, not perhaps not as a counterblast, but the phone manufacturers also thought that perhaps as a counter litigation, they would approach the CCI and allege that Ericsson is abusing its dominance in relation to the SEPs, to the standard essential patents that it holds. And the allegations were that they are charging excessive royalties, they are demanding unreasonable terms, etc. So now there's a separate, and I mean, for people who are not too aware, and even I'm not an IP expert, so but whatever little I know, I'll try and explain. So standard essential patents, there's a separate kind of regime under the IP law to deal with SEPs. So because these are patents held by a certain company, but they are essential for that technology to work. So for example, a USB drive, the technology or the patent is held by one company, but in order to ensure that there's interoperability between technology and universal application, so these patents are deemed as standard essential patents. That means they are essential for that technology to work. And there's an obligation, and these are done voluntarily. There are something called standard setting organizations, SSOs, to which all these patent holders become members. And those SSOs prescribe terms known as FRAND terms, which are fair, reasonable, and non-discriminatory terms. So every SCP holder is under an obligation to offer its patent to anybody who seeks a license on FRAND terms. So obviously Ericsson, so the CCI found a prima facie case, again ordered investigation. Ericsson obviously went in challenge to the Delhi High Court. Ericsson's argument again was something similar. They said, look, the Patents Act and coupled with this whole SEP regime is a complete code. It deals with all the issues that the informant has raised before the CCI. So the CCI's jurisdiction is completely ousted. And the Patents Act is sufficient to deal with it. So the CCI did not have jurisdiction to deal with this. So the single judge of the Delhi High Court rejected these contentions. He held that while the Patents Act is a complete code and it can deal with everything, the two acts have to be read harmoniously. And if the same set of facts can constitute a violation of the Patents Act and the Competition Act, there's no reason for the CCI to not proceed. So again, so essentially, and this, I mean, so just to put it in context, Ericsson, the judgment came out before the Supreme Court Bharti Airtel judgment.
Yeah.
So the judge did not at that time have the benefit of this judgment. So he went ahead and said that no, both have concurrent jurisdiction and they can proceed simultaneously. This is of course now under challenge before the division bench. Yes. And the Bharti Airtel decision of the Supreme Court would have a bearing, because I think ideally the same logic would apply here. They would say that look, there are certain basic issues that are pending in the suits before the Delhi High Court, and unless those are decided, the CCI will not be able to proceed. So that's, that's so in the IP space, I think we are kind of waiting to see clarity, because the division bench decision in Ericsson would give us a lot of clarity. But I mean, if I can't see them taking a different stand, and most likely, Bharti Airtel will be applied here. But of course, the question that you'll have to, and again, in my view, this is what the question that you'll have to look at very seriously, and the division bench would have to consider is, are they the same jurisdictional facts? Because as I said, if what is pending in the suit would not affect the outcome of the CCI proceedings, then I don't see a reason for them to stall it. It's only when the exact same facts are pending adjudication before the two, only then I can see a conflict happening. Otherwise, there's no reason for the two to proceed separately.
Absolutely. And I think the major issue, because I was also doing some research and at that particular time, was the fact that it was with respect to pricing.
Yes.
The royalty that Ericsson was imposing upon Micromax. And Ericsson was saying that, okay, when it comes to royalty issues, why does the CCI have to interfere when we have a patent authority looking into that?
Yeah.
Micromax was trying to say that, okay, the patent authority might tell you what should be the correct price. Okay, like what is the price, and like it should be this or this, like 2 rupees, 3 rupees, whatever it is. But whether that particular pricing is correct or not, keeping in mind the competitors in the market, that is something for the CCI to determine. And why this was not a very big problem, because I was following the international cases as well, because the SEB litigations have kind of flown from US and EU. And like you've said, in US over there, the FTC and the Supreme Court, they only had the authority to give these kind of decisions. The authorities over there were only giving decisions with respect to pricing, that what should be the royalty pricing. That is not something the CCI will have over here.
Correct.
That division has created such a big ruckus, which was kind of easily simplified, like adjudicated in the US and in fact in the EU.
Yeah.
So yeah, yes sir, do you have anything to like add to that?
Yeah, no, so just another point, I think, in the EU and US, I'm not too aware, but in the EU, I think the issue was slightly different, because what the EU courts were looking at was whether the very act of seeking an injunction by an SEP holder can amount to an abuse of dominant position.
Yeah.
And the courts have said, yes, it can, because if you have offered FRAN terms and that there has been some kind of breakdown in negotiation, or that you've been unreasonable, then going and seeking an injunction could amount to an abuse of dominance. So that was, so they weren't really looking at the royalty issues, but yeah, I mean, it all depends on what exactly are the facts pending in those suits versus what is before the CCI.
Yes, sir. And sir, with respect to copyrights, like this was with respect to patents, is the situation, is there, do we also have such conflicts when it comes to copyrights and competition law?
Yeah, so copyrights would come up with similar issues. There's one case, although the jurisdictional angle, it's pending appeal actually. So what happened in this case, this was the super cassettes matter. So where Hindustan HT Media had filed an information against super cassettes.
Yes.
The allegation was abuse of dominance by excessive pricing, essentially.
Absolutely.
And there was a jurisdictional challenge raised by super cassettes, because they said, the royalties are fixed by the copyright board. So therefore, how can you then sit in adjudication on that, saying whether it's excessive or not? Ultimately, although, the question there became a little infructuous, because the CCI did not return a finding of excessive pricing. They said, no, we can't determine whether it's excessive or not. So the issue became a little infructuous there. But yes, just similar issues could arise there, because just like how royalties are determined through FRAND under the patents regime, the copyright board in certain instances decides the royalties, and therefore there could be an issue of does the CCI then have the jurisdiction to look into whether that royalty is reasonable or not?
Absolutely. So we've covered telecom and we've covered IP. What are the other sectors where again there is an overlap, if we were to come into the oil and gas sector?
Yeah. So, actually, if you literally, and I was just doing this exercise, just before this webinar, if you open almost any regulators, the statute or the legislation, the preamble would always say that the purpose of that regulator is to protect the interests of consumers and ensure competitive markets. And everywhere there is such an objective, there is likely to be a conflict, because the CCI's, the Competition Act's objective is also similar. Although of course how they achieve it could be different, but but the objective is similar. So let's take the example of oil and gas. So the PNGRB, the Petroleum Natural Gas Regulatory Board, is one of the regulators for oil and gas, at least in the distribution segment, not so much in the exploration and production. And there again, if you read the preamble, it says that the PNGRB's objective is to protect consumers, ensure competitive markets, etc. Now, although there is, and this is something that perhaps judgments or the courts have not had a chance to look at in very much detail, but one big difference between how the CCI functions and how sector regulators function is sector regulators often have an ex ante approach, which is that they try to correct the problem by framing regulations at the beginning and regulating the conduct of players. Whereas with the CCI, it's almost always ex post facto, meaning that once the conduct has happened, they come in and on a case by case basis assess whether there is a violation or not. That's not to say that but that's the problem is that the sector regulators may also have adjudicatory or ex post powers. Like for example, telecom has TDSAT, and even PNGRB has a adjudicatory system where it adjudicates violation of its own regulations. There's a separate appeal mechanism, so there's a full blown adjudicatory process there as well. So so far we've not had cases, but potentially all of these are actually sector conflicts that could arise. Oil and gas, definitely. To give you an example, for one of the PNGRB regulations is on owners of pipeline systems. So for example, let's say a company X, like for example, Indraprastha Gas owns the gas pipeline network in Delhi. Now they are under an obligation to provide at least a certain minimum percentage. I don't remember the percentage now. It could be 30 or 40%, but a minimum obligation to provide some percentage of the space on their pipeline to competitors, because otherwise they are a virtual monopoly and they could completely keep competitors out.
Absolutely.
Now, if there's a question of whether this regulation is violated, this could, again, very well cause a problem, because somebody could go to the PNGRB saying that this is a violation of the PNGRB regulations, and also come to CCI saying this is abuse of dominance because he's not giving me access.
Yeah.
So, potentially, it's, these are conflicts that are waiting to happen. And, of course, the wider question is, do you take the same approach? So, for example, can you just take Bharti Airtel and apply it to all sectors? Or would you need a nuanced approach to each sector? This is, something that's open to debate, and we'll have to see how we can go about it.
Which is problematic because like we have bodies like TRI and TDSAT which have now started delving into competition law related issues, like you said, on predatory pricing. But we may not have such approach being taken by other regulatory bodies. What if they're following their traditional method of dealing with matters?
Correct.
So what happens over there?
Absolutely. And I think, I think two things at least that I would say is that one, you need a clear, and this is actually not just a question of interpretation, but it's also a question of policy. So at some level, this is, it's not just about how the statutes are worded, etc., but also a wider policy perspective. So, so yeah, I think unless you have either two things could happen. One is that the government comes up with a clear policy objective that, with each sector regulator, how will they coordinate with other sector regulators, who comes first, who comes second, etc. Or at least, the courts take a very clear view, like, like in the US or in the UK, that either you say that where the regulator is completely well equipped, then let the regulator look at everything. Or you say that, like the UK system, well, you say that, no, let competition law be enforced by everybody else. So, but either ways, I think the situation right now is not very satisfactory because it leads to a lot of problems practically. It could be used to stall proceedings very easily, which is what we see happening.
According to you, is the Supreme Court judgment not giving enough clarity at the moment on the situation?
Yes, according to me, absolutely, because there are two problems with, as I said, it doesn't clarify what is a jurisdictional fact, because it can't be that any dispute pending between two parties is a jurisdictional fact, and therefore, the CCI proceedings should stop. And the second problem with the judgment is it says that, till the sector regulator decides, you wait. But does that mean only the sector regulator, or does it mean the entire appellate process? Because that would be a very long time period. So we definitely need clarity on these two aspects, and maybe future judgments would help us, but we'll have to wait and see.
So, sir, I want to come to another very question about sector. Something that even some of our viewers are asking right now is with respect to the securities market and
Yes.
the SEBI specifically. That because I believe there are even some similarities in terms of certain terms and I don't know. Actually, you can elaborate better on that. So, what do you think are the prime conflicts happening in the securities market and the conflict between SEBI and the CCI right now?
Yeah.
That securities lawyers should actually know of.
Yeah. So it's again very, very similar. I think the issues, again, just like how we discussed with PNGRB, with TRAI. So SEBI's mandate would be to primarily protect investors, and traders, ensure that the securities market works well. So, and SEBI also again has both ex ante powers as well as adjudicatory powers. So it can look into violation of its own regulations. A lot of these regulations would overlap, because any regulations that are made in the interests of investors would obviously be pro consumer, pro investor. So violation of those norms, somebody could say, is also an abuse of dominance. So recently one judgment that the CCI has passed is in relation to the National Stock Exchange. This is not that earlier case of zero pricing. This is a more recent order, where a lawyer filed an information against NSE saying that they were discriminating in providing something called co-location services. Now, I'm not too sure of what that technology means, but basically the allegation was that this service, which was supposed to be provided to all traders on a non-discriminatory basis, was not being provided to everyone, and certain traders were being preferred. And there was actually a long pending investigation before the SEBI on this, right from 2015. And he approached the commission saying that the CCI must also investigate it. The CCI, perhaps in deference of the Bharti Airtel judgment, although it's not directly referred to in the order, the CCI says that no, because the SEBI is seized of the matter as of now, we would not have enough facts to proceed, so we would not proceed at present, and they close the matter. So I would say that as long, at least this order seems to provide precedent that the same principle of Bharti Airtel would apply in SEBI. So if there are jurisdictional facts pending before SEBI, then the CCI would have to await of the SEBI on that.
So this was with respect to jurisdictional conflict between CCI and the SEBI. But
Yeah.
I believe there's also another conflict with respect to this particular aspect of control. And why I ask is because you have been a transactional lawyer as well, and have dealt with mergers and acquisition related matters.
Yeah.
So I wanted you to throw some light on that, because that's also quite an important conflict that is happening with respect to the definition of control and how it is
Absolutely.
interpreted by the SEBI and the CCI, which
Yeah.
I believe is not very similar. So
Yeah.
can you explain the conflict?
Yeah. I mean, perhaps, and I'm perhaps making a very controversial statement, but but this is my view. But I actually don't see that there's a conflict, because a term is interpreted in the context of the purpose of a particular law and what it seeks to do. Now, what the definition of control under SEBI is, is tuned towards achieving the objectives of SEBI, which is to protecting minorities, minority investors, etc. So certain certain rights which are kind of like in the rights over your business plan, rights over appointing key managerial personnel, etc., are not considered control under the SEBI definition. They are only considered investor protection rights.
Yeah.
Whereas the CCI has a much broader and expansive definition of control, because it looks at any kind of strategic influence that somebody has on a company as control. Now, there's a reason for this difference and different interpretation, because the CCI and the competition law are looking at control from the perspective of competition dynamics. So, for example, when let's say a SoftBank picks up a 5% stake in Uber and it already has a stake in Ola.
Absolutely.
Now, if you just look at it in a silo, you could say, oh, it's 5%, it's just one board seat. How does it matter? But actually what the CCI is looking at is as we go back to the original, the basics, like they're looking at the market as a whole. So if a SoftBank has a stake in Ola, it also has a stake in Uber, which are competitors. Can it end up, controlling the two or influencing the two to not compete with each other? So, the definition of control under the CCI, and let's face it, and the other thing that people often, and I know that transaction lawyers and even me as a competition lawyer earlier when I defended the parties have argued vociferously, but it's not that the combination proceedings under the CCI are adversarial. It's not that you have violated something. It's just an approval. Yes. So what the CCI is doing is they're just widening that threshold at the basic level to say that, okay, we want to look at your transaction and therefore we will widen the definition of control. You come to us, but if you are convinced that there's no competition issue, we'll clear it. And and there are so many, you are aware about all the measures they've taken to speeden up the approval process. There's a green channel, and nowadays I believe most of the approvals are given quite soon. Yes. So to be really honest, I think I don't think that there is a conflict, and sometimes terms would have different interpretations under different regulatory regimes. So that's perfectly acceptable.
Absolutely. Mr. Shrikar has actually raised another sector that has attracted quite a lot of scrutiny. That is the data protection sector.
Right.
The intersection with competition. Now, we know we don't have a proper authority or a sectoral body such as SEBI or any other SEBI or TDSAT. But with the bill coming in, we do see a data protection authority coming into the future. So his question is that, could Sir please speak a little on the competition issues he preempts once this data protection authority comes into the picture? Like, what are the big data issues that could arise from a competition perspective?
Absolutely. In fact, people have already tried using the CCI in relation to data issues. Yes. Complaints have been filed against WhatsApp, alleging that they are sharing user data with Facebook without consent, and and the Facebook is then using that data to provide targeted ads. So there was a case of Vinod Kumar Gupta versus WhatsApp. There, ultimately, the CCI found, of course, closed the case. They found that this is purely a privacy issue and not a competition issue. But I think that's although that judgment could perhaps change because coming in of the data protection bill, there are definitely, because see, the Competition Act prescribes imposition of unfair conditions, and we have seen the CCI take up what we would generally say are consumer protection issues, like for example in DLF, etc. So there's no, at least strictly from the law perspective, there's nothing stopping the CCI from also looking at this. In fact, the German competition authority is investigating Facebook for having
some sort of an order.
Yeah, that they are imposing opaque or not very transparent terms in relation to how they use their data, which is true actually. If anybody registers for any of these online websites, including Facebook nowadays, the terms are not very clear as to who gets the data, etc. So potentially, again, we could be seeing a similar conflict where conduct which could be violating the Data Protection Act and the regulations there could also be seen as a violation of the Competition Act.
Absolutely, and I think it becomes like a competition issue considering how big Facebook is. So the whole issue over there was that Facebook is actually using its pre-established dominance to indulge in this data privacy issues that are cropping up. Yep. So once we have a proper data protection authority in place, then these issues might start cropping up in the data protection space as well.
Absolutely.
And also, like, we've already started seeing a surge of collusion related issues that have come into the picture involving big data, that the cases that have been filed against Uber, the cases that have been filed against Ola, in these in these matters.
Yes, yes, absolutely.
So Afif has a question over here that on the free side of the market, the data is what becomes the price that we pay for our service. So in case WhatsApp starts taking more data, then in that case, won't that be called an increase in price? Can the CCI then intervene over here?
Yes, it could. So, in fact, to answer your question, the CCI has already considered this in not in relation to WhatsApp, but in relation to Google in its matrimony order, where Google argued that, look, I'm not an enterprise because my service is free, I don't charge. But the commission rejected that argument and said, no, the consideration that users pay to Google is the eyeballs. Because what Google is again like it's a two-sided market, just like what Abish was mentioning as the free side. The free side is the search engine, which you can use for free. But what Google gets from that is the fact that there are many people clicking and that it uses to monetize through ads.
Yes.
So the commission has held that, consideration need not necessarily be only in the form of monetary consideration.
Yes.
So it could be eyeballs, or as in the case of WhatsApp, it could be data. And in fact, there was a suggestion in the recent Competition Law Review Committee, which was looking into the Competition Act and amendments, that the definition of price needs to be amended to include non-monetary consideration. Ultimately, that wasn't added because it was felt that the definition is wide enough to include non-monetary consideration. But yes, that's definitely on the radar, and I would think that the CCI has interpreted price to mean non-monetary consideration as well.
Plus, I think even though that suggestion was not taken up, the CCI did try kind of including some of that when it kind of the bill now that we have has also included other criterias in terms of when it comes to merger and acquisitions and like when I'm talking about the thresholds. Earlier, we had very monetary related thresholds with respect to whether a particular merger requires a notification or not. But now the bill says that okay, now not only assets and turnover, we can also look at other criteria. So maybe data can also come into the picture, that what amount of data is actually being exchanged over here. What like that is, I guess, what he means when data becomes price.
Correct.
So that is one of the things that the bill is trying to incorporate over here. So, sir, apart from these particular sectors, what are the other sectors? Are there any other relevant sectors which have attracted as much scrutiny as the telecom sector has?
Not as of, I think not as of now, really. I mean, just in terms of the conflict with, CCI and sector regulators, I would say that, telecom, IP, these are the big ones. SEBI has featured a little bit as well.
Absolutely.
But I think perhaps, and just use this opportunity, two more points to point out, and these often come up for discussion. So one is in almost all these judgments, there's a reference to two sections in the Competition Act, 21 and 21A, which provide that the CCI can consult with other sector regulators in case there's an issue that crops up in relation to let's say that sector. So for example, if there's a telecom matter pending before the CCI can write to the TRAI and ask for its views. And vice versa. And any other regulatory authority can also consult the CCI on competition issues. So this is very often kind of touted as the solution to this problem. They say that, look, these provisions are there, they can be used, etc. These, in my mind at least, these are at best just aids, and they would not be a complete solution because number one, they're discretionary. It's the word used is may. Number two, in my experience, I don't think they're used very often. So, and even if they are used, even if, let's say, you consult another sector regulator, the likelihood of the other sector regulator saying go ahead, or that, or giving a kind of clear answer, because each regulator likes to protect their own turf. So, at best, these are, I would say just aids, but yeah, this is often kind of flagged. The other thing is that recently the CCI has amended its regulations such that when somebody files an information now, they have to necessarily disclose any other pending litigation they have with the parties.
Yeah.
So I think this is in aid of the CCI. I would say, as especially after Bharti Airtel, has become a lot more wiser about these pending sector issues, and I think this is in aid of that, to at least find out, okay, what are there other pending disputes, and whether that would have a bearing on the CCI proceedings. So the CCI also nowadays is proceeding a little more cautiously, much more mindful, and hopefully maybe that itself could avoid some of the conflicts. But yes, the problem remains that there are, the way, at least the system that we have now, which is this, the Bharti Airtel system,
Yeah.
there are problems with it, that it could be misused, and we do need more clarity.
So, keeping all these in mind, now since you are practicing competition law as well, when you have clients coming up to you having these sector-specific related queries, and given the current jurisprudence that we have on it, how would you approach? How would you now take up these cases, and what do you think the strategy of competition lawyers will be when they are dealing with such sector-specific matters?
Absolutely. I mean, so if I am, for example, if I'm advising the opposite party, now, after a 26-1 order, one definite option is, can we go to a writ? And, especially if there's a pending sector issue, we definitely explore that, and, to see if we fit within the contours of Bharti Airtel. And if we feel that we do, then I think, it's much, I would say, even like, let's say even more than 3-4 years back, now it's almost in every case you do consider, can we go to writ? Whereas earlier it was a lot more, let's just face the investigation and let it, get over. But now I think Bharti Airtel has opened that new avenue for at least parties being investigated to consider the option of a writ. But obviously, as a competition lawyer, speaking not for any client, I would say, but that is a problem, because we don't want every single investigation stuck in the courts, and therefore and which is why I keep saying that unless we have a strict interpretation of what is jurisdictional fact, and a strict interpretation that that the CCI proceedings should not wait till the finality of the sector regulation, meaning all the way through appeal. The CCI's powers can get quite stifled.
Absolutely, because the CCI does not exactly cater to one particular sector, unlike other regulatory bodies. So if you start building these walls, then the CCI effectively loses the power to adjudicate on any matter whatsoever.
Correct.
Then I think the only sector that is left with the CCI is probably real estate. But even there, we have a RERA.
Exactly. I mean, so the more and more, you come up, the more sectors that come under regulation, the more this problem is going to come out. So you do need a clear, so which is why I keep saying, unless you have to have a clear policy answer, and, perhaps actually the answer is not even in courts. Perhaps, it's the government that has to amend the law, come out with some kind of a clear policy, because this is a real issue, and it's only going to get worse the more sectors get added.
In fact, this is, I think, one of the sectors we forgot to address, that is the real estate sector, because
Absolutely.
we have so many complaints that come before the CCI, which get dismissed because the CCI says the parties that, listen, you're bringing in contractual disputes to us, go to the consumer forum. And similarly, when like some parties go before the consumer forum, I think that problem doesn't arise as much because they're mostly looking for damages. So what has your, if you could quickly just speak a little about the real estate sector now that we have a RERA in place, what has been the overlap over there? Because we have so many developer related issues coming up.
Yeah. So I think, if I may say, I think what CCI did was, so you can, I mean, how the competition law has applied to real estate sector can be divided, I think, into two phases. This is pre-RERA and post-RERA.
Yeah.
So, pre-RERA, I think the CCI felt compelled to intervene because there was no sector regulator.
Yes.
And because they realized that consumers were suffering, they kind of, brought it under the umbrella of Section 4, and, the first case, DLF, they intervened.
Absolutely.
Now that then opened up Pandora's box, numerous other complaints. Of course, many complaints got dismissed at the threshold because there was actually no dominance. People were, just trying their luck.
Yeah.
But DLF itself got penalized, or at least there were orders adverse to it in several other matters later. most recently even Jayaprakash, JAL also got penalized.
Yes.
So I think what the CCI now post RERA, I think the CCI should be a little more hesitant to intervene, because now that there is a specialized sector regulator, which obviously also has regulations in relation to exactly the same thing, or at least should be mindful of the RERA regulations. But I think what has happened is that because it has set a precedent, now it is compelled to follow that precedent. So the CCI does continue to entertain real estate matters. But I think in future matters, you'll definitely see a little more, I wouldn't say deference, but at least, they would refer to RERA regulations. They would see whether, how does the RERA deal with this? And perhaps even in appropriate matters, they might apply the ratio of Bharti Airtel and say that, no, this issue is pending before RERA, so we won't interfere as of now.
Absolutely. So I guess we have covered almost all the important sectors where there has been a spillover effect. So guys, please let me know if you have any question. I think Ruben has asked a question with respect to electricity, a
Yeah.
particular sector that's not very explored in competition. Section 70 of the Electricity Act gives powers to the CERC to try a company if it abuses its dominant position or enters into a combination which could cause AEC in the electricity industry. So so do they have sufficient powers? As they clearly have sufficient powers, how should they deal with it? I may have to revisit this particular section. I wouldn't know if.
Yeah, even I'm not aware, but I will. Okay, I will definitely get back to. I'll get back to you, and you can get back to them on this.
Yeah, certainly on this. That is that the actual language of Section 60, because this is kind of the language of the Competition Act.
Yeah.
It is there. So, Ruben, we'll definitely get back to you on this particular query, because this is quite interesting. And if this is what the provision actually says, then we, I think, have a very clear demarcation.
Actually, yeah, I'm just opening it, and he's right. So I'll just read out section 60. So it says the appropriate commission may issue such directions as it considers appropriate to a licensee or a generating company if such licensee or generating company enters into any agreement or abuses its dominant position or enters into a combination which is likely to cause or causes an adverse effect on competition in electricity industry. So yeah, Ruben is absolutely right. I think this is a major issue that could come up if somebody files. I mean, so far it's not come up because I think we've not had any case being investigated in the electricity industry. But yes, absolutely, this is a very, very and good catch, I should say, to Ruben. Very good catch. I wasn't aware of this.
And if we have similar provisions, so on a bare reading of this provision, if this is the kind of provision that is there in this act, so do you think this absolutely closes the door for CCI to look into anything whatsoever?
I think again you'd have to look at what. So it says appropriate directions. So whether that means what are those kind of directions? Does it cover everything that the CCI can, or is it? So because you also have to look at the remedy. So if the remedy is just that, like for example, if the remedy under the Electricity Act is only that the license gets cancelled or something like that, then perhaps both could go down. But otherwise, this looks pretty much like a self-contained clause in itself.
Absolutely. So Mr. Kranan has asked, so in all the cases, the parties approach CCI after complaint or case has already been initiated in the respective regulatory body. Has there been any case in which parties have directly approached the CCI before their own regulatory body?
Not that I'm aware of. I mean, at least if that happened, then I think the issue did not arise because parties then did not raise the issue of a pending sector inquiry. But yeah, so far all the judgments that I am aware of, there was first a pending dispute between the sector regulator, then one of the parties came to CCI.
I think that only happens in case of real estate where parties directly approach the CCI.
Yeah.
And instead of approaching RERA or the consumer authority.
Yes.
And then get an appropriate direction.
Yeah.
So yes, Kranan, will the Bharti Airtel judgment be then applied? Yeah, now since we have the Bharti Airtel judgment, I think the CCI will have to act accordingly.
Yes, absolutely. I mean, that is law. So
clarification on that.
Yeah.
So to summarize the entire discussion, I think we've covered all relevant factors. Guys, please let me know if you have any other queries that you would want to get addressed under this particular topic. Uh, uh, Someone has asked that do you see fair competition environment as a fundamental right, as right to freedom of business? I think that's like a discussion for another day. But if you could give your 2 cents on it.
Yeah, I think, in fact, this goes to the very root of competition law, and we should, as you said, I think we can have a whole discussion on this. But, there are, if you read, even if you look at the preamble of the Competition Act and even Section 18, there are two very distinct objectives that the Competition Act has. One is that it says it is to protect interest of consumers, protect free competition, but it also says protect freedom of trade.
Yeah.
So it's certainly linked to 19. And so, in fact, I would say that, and this is actually a topic that I'm quite interested in, which is, I try to look at laws and how they're linked. Where do they derive their power from the Constitution? Because every law has to derive its power from the Constitution. So if you ask me, in competition law, I would say it derives from Article 19, certainly, as well as, the directive principles of state policy, because the one particular directive principle, I'm forgetting the number, I think it should be the 38 or 39, which specifically says that the state shall endeavor to remove inequalities in income and ensure, monopoly and prevent monopolistic practices, etc. So these two would be, and these are objectives that have to be balanced out. In fact, the entire purpose of competition law is to ensure that there's a fair competitive process. But having said that, let me clarify that competition law is never to protect just one competitor or to protect small competitors. That's, it's the process of competition that is important.
Absolutely, absolutely. In fact, Anuja has actually highlighted something important that has come into with the amendment bill, that considering there is an extension of the IPR exemption to abuse of dominant position in the amendment bill, what impact does it have on the IPR sector? And CCI's jurisdiction in considering whether the IPR exercised by a dominant entity is reasonable or not.
Yeah.
It's a very important change that has been
correct. To me, actually, in my mind, I think this was, I would always see this as implicit in Section 4, because in Section 4, you are allowed to objectively justify your conduct. And an objective justification could include IPR. So, in a sense, this is actually just making obvious what was already implicit. But certainly it does now recognize that, reasonable exercise of IPR is a defense. But, again, there's a lot of scope for the CCI to interfere, because there are specific conditions. You have to show that it was reasonable, the exercise. You have to show that it was necessary for protection of your IPR. So it's not a very broad exemption. It's quite a narrow exemption, actually.
Absolutely. Guys, we'll take up one last question before we end the session for the day. Aditya, I think you've raised your hand. I'll just unmute you. And you may ask your question. And guys, this will be the last question we take up. Yes, Aditya.
Thank you, ma'am. Thank you, sir. It was a wonderful session, ma'am. This is slightly an off-topic question. I heard in the course of this discussion that sir has also been a transactional lawyer. So, sir, for someone who ultimately wants to go to commercial litigation, how does transactional work helps him? So. Yes, sir.
I think,
for example, working in mergers and acquisition. Yeah.
Absolutely. So I think how it helps, Aditya, is that when you work as a transactional lawyer, you really get into the nitty-gritties of how a transaction works. Interacting with a client, how is, because if you're just a litigator, you're probably not in, let's say, let's just take an example. There's a merger and acquisition transaction. Which requires, let's say, multiple approvals from the NCLT, CCI, etc. If you are purely a litigator, your role would only come in once all the agreements are signed, and then you have to basically just file the petition before NCLT for approval, or whatever else, some regulator, etc. But being a transactional lawyer helps you be involved right from the beginning. So you understand the purpose of the transaction, what they're really looking at. It teaches you how to draft agreements, and more importantly, how to read agreements, because agreements are drafted, are heavily negotiated. and each word there is inserted with a very specific purpose. So if you've been a transactional lawyer, it really helps you, understand these commercial documents, commercial terms much better.
Absolutely. Thank you so much, sir. I hope, Aditya, your query was resolved. So that's it for today. We'll take any guys. If you have any further queries, we can definitely take it online, and I can share it with sir, and he can come back to you on that. And for people who would want to have sir's email ID, if it's okay with sir, I'll share it with them.
Yeah, no problem.
Okay, perfect. So guys, thank you so much. You all of you have been a fantastic audience. Thank you so much, sir, for sparing this time and taking up this webinar for today and
Not at all.
discussing this particular topic in detail. I'm sure there's not been any other forum where all these sectors have been dealt with in so much detail. So once again, thank you, sir.
Thank you, and stay safe, everyone.
Thank you, guys. See you all for the next session that may be happening in a few hours. Thank you, sir.
Thank you.
Yeah, so actually what I'm going to do is I'll just type out your email ID on the chat box.
Okay.
To refer to. If you could just spell it out, because I think only I have the part to chat to type out on the chat box. So if you could just give out your email ID, type it out over here.
It's Avinash, Avinash.
Yes.
Dot ABA, A for America, B for Bangalore, A for America.
Yes, sir. Done.
At gmail.com.
Okay, perfect. Thank you so much, sir. Thank you, guys. Good day, sir. Thank you so much. Bye, guys.